An act is not an abortion if the act is done with the intent to A, save the life or preserve the health of an unborn child, B, remove a dead unborn child whose death was caused by spontaneous abortion, or C, remove an ectopic pregnancy. The definition is found at Chapter 25, Section 245.0021 of the Texas Health and Safety Code. Ectopic pregnancy means the implantation of a fertilized egg or embryo outside the uterus. And removing an ectopic pregnancy is not an abortion. This definition is found at Chapter 245, Section 245.002, 4A of the Texas Health and Safety Code. 3. Reasonable medical judgment means medical judgment made by a reasonably prudent physician knowledgeable about a case and the treatment possibilities for the medical conditions involved. This definition is found at Chapter 170A, Section 170A.0014 of the Health and Safety Code. Medical emergency, number 4, means a life-threatening physical condition aggravated by, caused by, or arising from a pregnancy that, as certified by a physician, places the woman in danger of death or a serious risk of substantial impairment of a major bodily function unless an abortion is performed. This definition is found at Chapter 171, Section 171.002, 3 of the Texas Health and Safety Code. Number 5. Major bodily function includes, but is not limited to, functions of the immune system, normal cell growth, digestive, bowel, bladder, neurological, brain, respiratory, circulatory, endocrine, and reproductive functions. This definition is found at Chapter 21, Section 21.002, 11A of the Texas Labor Code. 165.8, abortion ban exception performances and documentation. And I believe this is the second part of the rule. A, an abortion shall not be performed in this state unless it is performed in compliance with all provisions of Texas Health and Safety Code Chapters 170, 170A, and 171, in addition to any other applicable federal and state statutes, rules, and court opinions. B, in addition to the requirements above, the physician must specifically document in the patient's medical record, 1, that the abortion is performed in response to a medical emergency. A, underneath 1, that places the woman in danger of death unless the abortion is performed or induced, or B, to prevent a serious risk of substantial impairment of a major bodily function of the patient unless the abortion is performed or induced. Number 2, the major bodily function or functions at serious risk of substantial impairment. 3, what placed the woman in danger of death or what was the serious risk of substantial impairment. 4, how the danger of death or serious risk was determined. 5, how the decision was made to proceed with an abortion based on reasonable medical judgment, including A, what diagnostic imaging, test results, medical literature, second opinions, and or medical ethics committees that were used or consulted, and B, what alternative treatments were attempted and failed or were ruled out. Number 6, how determination was made that performing a procedure in such a way as to give the child the best opportunity to survive would create a greater risk to the woman. And 7, whether there was adequate time to transfer the patient by any means available to a facility or physician with a higher level of care or expertise to avoid performing an abortion. The third section, 165.9, complaints regarding abortions performed. A, the Texas Medical Board will review complaints and perform investigations regarding abortions using the board's standard complaint process. B, if a complaint is determined to be jurisdictional to the board will use independent expert physicians as provided in Texas Occupations Code, Section 154.0561, to review the available information, including the patient's medical record. C, any decision by the board to either dismiss the complaint or discipline the physician who is the subject of a complaint is separate and independent of any other possible criminal or civil action under the law. If the board is aware the licensee is subject to a pending criminal or civil action, then the board may defer or delay action. Depending on the outcome of criminal or civil action, Texas Medical Board retains the authority to investigate and potentially take disciplinary action. That is the text of the rule. I'm now going to open it up to the board members to ask questions and to deliberate between us as board members.
I have a question.
Dr. Quinones.
In section 165.7 under definitions, item 1, abortion, item B, remove a dead unborn child whose death was caused by spontaneous abortion. Should that not be spontaneous fetal demise?
The specific language is coming directly from Chapter 245.
Okay.
So that's how the statute is worded.
Okay.
And again, for clarification, these definitions were put in here because some of them were things that people would come to the board and ask some questions about. Well, what about ectopic pregnancy? What about, if the fetus has already expired? What is reasonable medical judgment? What isn't a medical emergency? What is a major bodily function? And so we try to put all that stuff together in one place to make it easier for people to see and to make it clear that this is what the board will be looking at as far as definitions for those terms.
Okay.
One other thing that I will just go ahead and state here, and I understand that there was a desire to have a list of potential conditions that would fall under these definitions. We've had this experience somewhat with COVID, where we were looking at conditions that would meet the criteria for not allowing elective surgeries. And it was very difficult for us to go down that path. We actually put out FAQs at the time, but we also still, in spite of that, we're getting a lot of questions about different circumstances out there that frankly we could not anticipate or really get into the minutia of every single case. The reason it's difficult to actually adjudicate that is because you can have a very similar condition, but depending on the other circumstances that are going on with that case, and that's why we have expert panelists that look at that, medical judgment is really not whittled down to a list of conditions. You're really looking at the totality of an issue that goes beyond a specific circumstance. I understand it may be easy that you may have a chromosomal abnormality, we can list a couple of things here and there, but when you do that, it becomes difficult to go into what may not have been listed. So if this specific one wasn't listed, does that mean that that's not qualified? You have to go back and actually redo all the rules again. Did you not anticipate this one specific circumstance? Things may change as far as what medicine can do to save a baby's life. So a condition that may apply now may not necessarily apply later on. And as the Supreme Court ruling said, it really defers to medical judgment based on what the standard of care is out there in the community based on specific and certain conditions. And as such, you can't put a list out there that defines what medical judgment may or may not be with every single circumstance that's out there, because not every circumstance is exactly the same. You can have two conditions, but two very different circumstances, including where it may have happened. Was it in an area where you could not transfer the mother to an area of higher level of care? And that was actually included in the rules as to whether that was possible or not, which of course would have to be very specifically documented. So given that kind of circumstance, you can have a condition that would be potentially looked at one way in one scenario, but the exact same condition in a different scenario looked at in a different way. And you actually cause more harm by listing conditions without understanding the nuances. You restrict what our expert panelists would be able to do and what they would potentially be able to determine without looking at all those specific circumstances. So from that standpoint, restating definitions that are already in the statute and explaining what the process of how we would deal with a complaint, which primarily is, again, going to our expert panelists, which, as you may have heard earlier on, are physicians out in the community who are experts in the specific field, who can look at a case in an exhaustive way, look at all the circumstances, look at the medical records, look at the documentation, look at the nuances, look at the mitigating factors, and come up with a recommendation to the medical board. And the way that process works is that we have two expert panelists that are typically looking at it. If they are unanimous in their recommendation from the standpoint of standard of care, it comes directly to the medical board that way, whether it's unanimous in saying that standard of care was met, or whether it was unanimous in saying that standard of care was not met. If the two of them disagree, it goes to a third expert panelist that goes into a lot of detail as to what their recommendation would be. And at the end of the day, again, it comes to the medical board as a whole. We hear it as a whole, and we can opine on it. Even when we make a determination if something was followed as we think it should have or not, even that can be appealed and go to SOA, which is the State Office of Administrative Hearings, as you have seen earlier today with those two proposals for decision. When it goes to a SOA hearing, it goes to an administrative law judge that looks at the findings of fact. In those instances, both sides can actually provide more evidence. There's discovery. It's a full-blown court process hearing. The PFD, proposal for decision that is given by that judge, comes back to the medical board, and we as a medical board are confined by the findings of fact that the judge has determined. And again, that is based on expert panelists, expert witnesses, that was heard on both sides. And from that standpoint, we are able to look at those specific findings of fact, and we can make a judgment specifically based on those findings of fact. We can't change the findings of fact, but we may or may not have discretion depending on what that is. As I said earlier, if it's a felony conviction, for example, we don't have discretion. But in other instances, we have discretion. There may be instances where we would have to refer it to law enforcement. There may be instances where it may involve an institution, and we refer it to another state agency if it's not involving specifically a physician, or if it's involving another licensee. For example, if it's a nurse practitioner, it may involve the nursing board. If it's a physician assistant who are operating under prescriptive authority, it would fall under the medical board because physician assistants are under the medical board. So again, just kind of going back to that whole overall process is that giving an exhaustive list, we felt, again, this is up for debate. I'm sure we're going to hear a lot of comments as public comment comes out in the next 30 days. And this is something that we will look at and we will debate again, and we can deliberate on, and we can make a decision. But that is the overall arching theme from our standpoint as to why we were very hesitant into putting an exhaustive list out there, that in fact it would hinder the ability of specific circumstances to be looked at in a way that would be fair to both parties.
Yeah, and to expand on that a little more, when it comes to taking our cues from the Supreme Court opinion in the Cox case, again, as you read out about, it doesn't take a court order to do one of these procedures, and it's left up to the judgment of a physician. And then also the court, in their footnote, talking about how the board put out some guidance when it came to elective and non-elective procedures during the COVID pandemic. So we took both of those cues, and that's kind of also what helped model what we have here as far as a rule. It talks about it is the physician's decision, and if the physician is going to do this, these are the things that need to be documented. And just like in COVID, we did not put out an exhaustive list to say these type of procedures are elective and these are non-elective. It was up to the physician to make that call. Just be sure and document why you did what you did in that circumstance. And so that's, again, what you're seeing here.
And of course, we defined what that process is as far as a physician looking at different issues that are out there. And again, it's about documenting the Cox case very specifically, really centered around a documentation issue. And this really highlights to our own physicians that it's extremely important to, number one, make that judgment based on the criteria that we've laid out, based on the definitions that we've laid out that are coming specifically from statutes, and making a judgment based on that. Frankly speaking, our belief as a board is that anything that goes beyond that is outside of our jurisdiction. That for us to opine beyond those certain set of circumstances as defined by law would really have to be something that would be addressed by the legislature. We can only do so much. We can define what the process is. We can put definitions out there as far as medical emergencies and other nuances that are out there. We can describe what the process is that we go through when somebody raises a question as to what that looks like. But we can't define things like rape and incest being a certain condition. That is not under our jurisdiction. We can't go into very specific circumstances that are not listed in these definitions or that are not specifically listed in law. The only way that that can be dealt with, one way or the other, is by legislative action. We as an executive agency, as part of the executive branch, our ability to do anything is to enforce the law as it's written. We do have some discretion as to help define what the law says, help to expand on how the process works, but we do not have discretion in rewriting the law or changing certain provisions of the law. That has to be a legislative action. So with that, any other questions from the board members?
No.
Any suggestions for, or any questions about certain language, any suggestions for changes? Okay, if there isn't any, is there a motion out there?
I'll make a motion.
Dr. Bhatia?
Motion to accept the subchapter B, exceptions to abortion ban as
I'll second it. Excuse me, Doctor.
we're going to say, as elaborated by Dr. Zaffron just now.
Okay, there's been a motion made by Dr. Bhatia, it's been seconded by Mr. Kokonos. Is there any
And Dr.
discussion?
Zaffron?
Yes, Mr. Frederick.
Dr. Zaffron, let me jump in and clarify. Dr. Bhatia, your motion is to publish the rule in the Texas Register as was read out and proposed by Dr. Zaffron. That's what you want to do, right, is to publish it in the Register for the comment period.
For the comments thereof, yes, that's correct.
Okay.
All right, thank
Yes.
you.
To make that clear, we are not adopting a rule, we are publishing a rule for comment. And then if there's going to be consideration of adopting a rule, it would be based on deliberation at the next meeting, as I mentioned earlier, after looking at the public comments, deciding if there's going to be any changes. If it's substantive changes, then it would need to go out for public comment again. So you've heard the motion from Dr. Bhatia, there's been a second by Mr. Kokonos. Is there any further discussion?
Can I get a
Ms. Morgan.
clarification? So this is out for public comment for how long?
The public comment is for 30 days.
Okay.
So a minimum of 30 days.
Okay.
So it can be actually up
A
to the next
minimum
board
of,
meeting.
Yeah,
And
it's
this
a
is,
minimum of 30
this is
days.
in
It's a
the
minimum.
registry for public comments.
It will go out to the registry
Yeah.
as soon as they put it out into the public registry, which I think is fairly soon. And then when it's out in the public registry, it will be out there for public comment no less than 30 days. We meet again in June, which is more than 30 days, so at that point, it could be worth 90 days worth of public comments. But that is the soonest that we will deliberate it, unless for some unforeseen reason we decide to have an emergency board meeting exactly 30 days from now. I can almost assure you that won't happen. But it will be at the next board meeting that we would further consider this proposed rule. All right, any other questions?
and Dr. Zaffron, just so the board members are clear, and Ms. Carlton, I think you hit on that. Yes, Ms. Morgan, the law requires that it be put in the Texas Register. It is a minimum of 30 days. It can be extended, as Dr. Zaffron said. There is also the potential, and I think Dr. Zaffron, you mentioned this morning, and I think it's
Stakeholder
important, that there's the potential for a stakeholder meeting. I think we're planning at least one to be sure we get input. And then the process goes, as you said, Dr. Zaffran, we as board staff will assemble the comments, we'll look at those. If there's anything that may need to be changed, modified, it will be brought back to you as a board. So there's a number of steps that will occur between now and the next board meeting if we get there, including, as I said, the stakeholder meeting. The other thing is, and Mr. Carlton, you may want to talk to the individuals that are at the meeting, that we have also, will have a link on our website if the rule is in fact adopted with the pending motion. It's going to be on our website. There's going to be a link with a comment form to facilitate your comments that you can go on and click and fill it out for the board. So those will be assembled for my staff and my office along with the board, literally almost automatically, because we've got the form there. So we may want to cover that in a bit.
Yeah, absolutely. That is something I was going to cover before we begin the public comment portion of it.
Yeah. And Brent, can you just please help explain to everybody how we're going to announce the stakeholder meeting? Yeah, like we said, there's going to be at least one. Again, depending on how that goes, there may be additional ones, but that will certainly be announced.
Do you want me to cover that now or
Yeah,
do
go
the
ahead.
motion? Okay. So stakeholder meetings are an opportunity to have, kind of like we're doing here. It can be in person and hybrid and virtual also, and have individuals take that opportunity to provide comments to the board and to board staff. We will have at least one of those. We may have more than one, depending on the amount of comments we get and requests that we get for stakeholder meetings. Obviously, we want to get as much input as we can from the public on it. Whenever it comes time for doing comments, it really is most beneficial to the board when those comments are submitted in writing. It's also okay if you want to appear and kind of read through your comments that you're presenting in writing. And then there could be an opportunity for a back and forth, not in this forum for this meeting because it's a public comment period that we're going to get to in like a kind of a normal open meeting. But when you have a stakeholder meeting, you have more of an opportunity for a dialogue back and forth to ask questions and get clarification. But again, it is really most helpful for the board if we get the comments in writing, either through the web form that is going to be on our website, and we're going to try to put as much information on our website as possible to help you guys stay informed of where we are in the process and the current information. Again, all that will not hit the website until the board actually votes to adopt publication of the rule. But again, we will have more than one, at least one, probably more than one stakeholder meeting. Again, this may take a while to go through the entire process. Through the Administrative Procedures Act, the board does have to review every single comment that we get. We need to respond to every comment that we get. So this may take many months, and in all likelihood will probably extend past the June board meeting, possibly into August or even October.
All right, so there's a pending motion out there. Any further discussion? All those in favor, please say aye.
Aye.
All those opposed?
Any abstain?
Are there any abstentions? All right, the motion to publish the rule passes. All right, so with that, we are going to move into the public comment period.
Well, we're going to do the
And
contingent.
before we do that, I am going to do something that we don't typically do, which is contingently adjourn the meeting, because I want to make sure that if we don't have a quorum at the end of the public comment period, that we don't get stuck not being able to adjourn the meeting and then end up with a 3-month meeting until June. So
I'll make a motion to
go
adjourn.
ahead, Dr. Batsu.
Okay, so again, this is unusual for us, so the motion would be to adjourn the meeting at the conclusion of public comment.
Yeah, we're making that motion now, ahead of time. But Dr. Batsu, that's your
That's
motion.
my motion, yes. it is.
Seconded by Dr. Quinones. Is there any questions? All right, all those in favor, please say aye.
Aye.
All those opposed? All right, so that is passed. So with that, we're going to go to the public comment period. There's a very specific process that we put in place with this. I'm going to kind of hand this off to Mr. Carlton to help with this process and kind of lay out the rules and how we do this. As Mr. Carlton said, this is not really typically a period where it's a debate back and forth between board members and the public. We typically leave that for stakeholder meetings, so there will be other forums for that. But we obviously are very interested in hearing what you have to say. As many of us as possible are going to stay to hear as many of your public comments as possible. I'm going to be here probably at least until 3 o'clock, if all of you are still here until 3. But then I have to leave after that. But we are, you guys are very important to us. Hearing both sides of the issue is extremely important. As we said, this is a very, very emotional issue. There's a lot of nuances to it. We're trying as hard as we can to get it right within the bounds of what we are allowed to do legally. And we're starting the process today. We'll go from there. So, Mr. Carlton?
Okay, so this is the only item that's left. So as Dr. Zaffron said, we'll be here until public comment is concluded. Just like in, probably several of you, a lot of you have been to the legislature before. You probably will see we're not going to take any breaks once we start this. So if you need to get up and go to the restroom or get something to drink or whatever, you can move around. The board members will do the same, and we'll just keep going through this and listening to the comments. There is a limit to how many people we can have in this room. It probably may have already been explained to you, but there is an overall weight capacity of what the floor can hold. So that's why we can't just have everybody come in and have standing room in the room also. So what we would ask though is in consideration of other individuals that are here and that want to make comments that are not in the room currently, that once you make your public comment, if you would please be considerate of the other people that would like to come and make comments, and if you would mind trading places with them, kind of in one of the overflow rooms that's in the hallway, and allow them to come in and have the opportunity to make their comments also. One of the other things that we were going to do is there is the sign-up sheet that everybody, I believe, signed up on. Did anybody not sign up? Okay, good. We're going to go through the individuals that are here in person first, and then we'll move on to the individuals that are online. Presumably, not that their time is not important also, but they may not have to deal with issues like parking, and some of them may be in their office or their home or somewhere that it's perhaps a little more comfortable than where you are sitting in this room all together. So that is how we're going to proceed. We're going to go straight down the list here of how you signed in. Everyone is going to get 3 minutes. Obviously, we're going to be pretty strict with the 3 to keep this moving along, and in consideration of everybody else. So we will go ahead and get started. And first on the list is Steve Bresnan.
Mr. Carl,
Make sure your mic is on, the green light.
seems to be on.
Okay.
Is it on?
I can't see the.
Is it a green light on there?
There's a green light.
Okay.
All right, great.
Board members, Mr. Carlton, you don't get to be my age without learning a few things.
We can't hear you.
Okay, I'm sorry, I thought it was on. It wasn't on. Is that better?
Yes, sir. Thank you.
Okay, great.
Good. You don't get to be my age without learning a few things. And one of the things I've learned is that I would appreciate requesting if y'all would allow my co-petitioner, Amy Bresnan, my law partner and wife, to join me. She's second in the list there. And I'd like for her to go first if you don't mind, because I'll never hear the end of it when I get up.
Absolutely. You may defer to
Thank
to Ms. Bresnan.
I always open and Steve closes, so thank you for meeting our needs there. First of all, we just want to thank the board for being so courteous and so friendly toward us. We know that this is a difficult situation, and we know that you are not necessarily to blame for it at all, but nonetheless, here we are. So. Steve and I believe that nothing is more important than protecting pregnant women and mothers suffering conditions that threaten their lives or a substantial impairment of a major bodily function absent an abortion. And I want to make something very clear, and we've been asked this a lot. We are not representing a client. And at the risk of giving the lobby a good reputation, every now and then we do something out of conviction and not because we're getting paid. We do something because we believe it's the right thing to do. And frankly, more importantly, because we care about our state. Frankly, it's why we're all here. It's why we all came to the capital city to work in and around state government. There's nothing more important to us than Texas. And with that in mind, we are extremely concerned about the current situation that expectant mothers face here in Texas. And we believe that rulemaking is the right thing to do. But more importantly, the Texas Supreme Court believes that rulemaking is the right thing to do. And for that, y'all are to be commended for taking their advice, which they were not shy about giving in the opinion. And by the way, the good parts of that opinion are on pages 5 through 7, if anybody is interested. As we move forward, we ask that you not let the perfect be the enemy of the good. We also ask that you not make the situation worse. In fairness, the legislature did not know that Dobbs would completely overturn Roe. In fact, most of the legislation had already cleared both houses before the United States Supreme Court even announced it was going to take up Dobbs. And at that time, everyone believed it would just be up to 15 weeks and not at 0, which is where we are today. And I think that's important for people to remember when Steve talks about the passing of this hot button issue from branch of government to branch of government. So it's important to remember how we got here. I want to make this point, and I've made this point in the media. Our petition is nothing short of pro-life. We all know people who are concerned, young families who have expressed anxiety about starting a family under these conditions in Texas. And we all know somebody who under the pre-Dobbs, under the old law, who faced very similar situations to the ones like Kate Cox and other women who were able to be treated not only in the state of Texas, but in their city. They did not have to leave. Today, women have to leave. That is concerning. And I am not talking about elective abortions. I am talking about abortions where there is no choice. The mother will die if she is not treated. And finally, we are extremely sympathetic with the idea of not wanting a list. We go to the legislature all the time and fight lists. Sometimes we're for lists, depending on what the client wants. But we completely understand the apprehension around lists. And I do want to emphasize that in our petition, that was a non-exhaustive list, but we nonetheless understand. And finally, and I'm going to turn it over to my husband and law partner, Steve Bresnan. We do once again ask that y'all consider all 5 elements in the Cox case. I know that it sounds like some of them have been codified in the proposed rule. We do encourage y'all to consider all of the 5 elements. And with that, I will close and turn it over to Steve.
I'm just going to say that, we gave you guys a little bit of deference because you're the original petitioners. But in general, let's try to hold to the 3 minutes. Again,
I'm sorry.
I understand you guys are the original petitioners, so I'm going to give you guys a little bit of discretion.
Yes.
But if you multiply that by 100, it's going to be a very long day. So.
We're used to legislative hearings. We know exactly what you're talking about. And I'll try to make up the difference.
All right,
How's
thanks.
that? May I?
Yes, sir.
Yes.
Go ahead.
I'm used to knowing what I'm talking about when I'm talking about it. I think my friends in the back of the room will attest to that. And since we haven't seen your draft, I'm talking about something that I don't know about, except for what you've had the courtesy to read to us. But I'm not going to use my time complaining about process. I am going to thank you, Mr. Carlson and Mr. Freshour, for the very professional manner in which you treated us in our petition. We're grateful for that, and it speaks well of the board that you've done that, and Dr. Zafford, you as well. Thank you. We are here, I just want to quote, and I know that Dr. Scott's in the area, so I'm just going to quote out of one of the briefs in the Zorowski case, the following. Defendant's expert, Dr. Scott, similarly testified that care is now substandard and doctors in her hospital now refuse to intervene even as they acknowledge this is not the standard of care because they fear risking a felony or losing my board certification. Not all that's a direct quote from her, that's in the findings of the trial court, I believe. So that's what brought us here. You got people that are scared to death. They're facing death and they're scared to death. And we think that you can do more than it seems that your proposed rule would do. In that sense, we're disappointed. We see some things in there that can help guide medical decision-making. If I have to keep a record of it, I have to think about it. If I have to think about it, I'm making a judgment. I want to make one final comment. Even though you don't feel like you can do something about criminal exposure, that's not right. Reasonable medical judgment means reasonable doubt. A prosecutor must prove a crime beyond a reasonable doubt. If you give physicians sufficient guidance, sir, if you get sufficient guidance from this board and can make a reasonable medical judgment, you will have reasonable doubt when they try to put you in the penitentiary for 99 years. So we look forward to working with you on the process. We'll try to make our comments a little less animated going forward. And we thank you very much again for teeing this up. And for all those other people that will be involved with us, we expect to see a lot of you. Thank you.
Thank you.
Thank you, and thank you, Dr. Zell.
Thank you.
And by the way, congrats on the new days. This is quite a step up.
Just so that you guys know, this is not really our new digs. The new digs is actually down on the 4th floor.
That's right.
We're just glad to be out of the hobby building. Thank you.
Thank you.
Okay, I've got, is it Robbie Bosley?
I'm going to submit it in writing, please.
Okay, thank you. And Tom
That's okay.
also?
The same.
Okay, thank you. Is it McBerry? McSary? Sorry if I'm mispronouncing it. Mignon? No?
Do not wish to speak.
No?
Right.
Okay, all right. Raul Lopez? No? Okay. Leah Stewart?
Thought I was next. I was trying to be fast.
Thank you. Hi, my name is Leah Stewart, and I'm with the firm of Reed Clayman, and I'm here on behalf of the Texas Organization for Rural and Community Hospitals, TORCH, as many of you know it. I want to thank the board for publishing rulemaking on this issue. Physicians and hospitals work together to deliver care for Texas patients, and confusion about when reasonable medical judgment permits an abortion under the law is an unnecessary burden in delivering the best possible care. We also appreciate the board's commitment, as you've stated already, to ensuring the rulemaking process includes an opportunity for stakeholders to meet and provide feedback on the proposed rules. Care settings and available resources vary widely across Texas, and the rulemaking needs to provide clarity for that full range of care settings, and so I appreciate your comments earlier on that point. If the rules are not consistent with the legal framework set forth by the Texas Supreme Court or do not address the full range of Texas statutes that create potential criminality or other liability for Texas physicians and healthcare entities, then it might be a step backwards that will possibly result in delays or denials of necessary life-saving care to Texas mothers. So I want to urge you again to conduct rulemaking in a way that allows stakeholders time and opportunity to give meaningful input. Also support your approach of trying to put things that are in the statutes in one place to help cut down on confusion, and hope that there's more opportunity to consider that approach in the rulemaking process. Finally, I'd just like to say that it is appropriate and correct that the decision about whether a woman's medical circumstances warrant an exception to the legal prohibitions is reserved to those who are licensed to practice medicine in the state. We are confident that a strong rulemaking process overseen by this board could result in a meaningful improvement in the delivery of care from the current state. Thank you so much.
Thank you. Is it McCabe? No? Okay. Is it Hogan? Regan Hogan?
He's not testifying.
No? Okay. last name Crow. Her initials are CC. It's a little bit harder to read. Okay, we'll come back to that one. Micah Rodriguez?
I'm not commenting.
Okay. Is it Sue?
Yes, thank you, Mr. Chairman, and members of the board. I'm Sue Liebel with the Susan B. Anthony Pro-Life America, the nation's largest pro-life organization. Appreciate the opportunity to speak today. We believe that Texas law is clear. Under the state's pro-life protection, doctors can provide pregnant women who experience an emergency with the proper care. We know there are doctors who understand this law because the state's reporting data and statistics show that abortions under the Life of the Mother provision have continued at about the same rate each month since the Dobbs decision. Unfortunately, media misinformation and the medical community's silence has created some confusion. And there have been instances where doctors have lacked clarity. And this is an opportunity for you to provide crystal clear explanation, and we're very glad to see that you're attempting to do so and look forward to reading the rule. We suggest you focus on the following and educate doctors and maintain the policies put in place by Texas's duly elected representatives. You mentioned the legislature earlier. We look forward to submitting more in-depth written comments in the 30-day comment period, but we encourage you to consider this. Texas courts have never found the term reasonable medical judgment vague or confusing. Even though it's a standard used in many different types of statutes, the phrase reasonable medical judgment has only appeared in Texas case law 9 times. It's never been questioned as unworkable or too high of a standard. Texas courts have upheld references to reasonably prudent physician or similar types of phrases that apply to the reasonable men standard in the medical context. This too is an objective standard in Texas law. For example, physicians in medical malpractice cases are held to a higher standard, that of a reasonably prudent physician who takes into account their training and knowledge. I know I'm not telling you anything that you don't already know. There's an entire chapter of Texas law that governs how expert testimony can establish the necessary standard of care. These standards aren't new, and they apply equally under Texas's pro-life law as under other laws. Doctors face tough situations and must frequently make decisions according to standard of care to save patients' lives. Rather, Texas law prohibits elective abortions. It doesn't stop accepted treatment options for serious pregnancy complications. And there's also no immediacy requirement under Texas law. A doctor can intervene at a diagnosis if there's a foreseeable risk to a woman's life. So the Texas abortion law is not broken. There are doctors who are confused. The solution isn't to upend standing policy, but rather to educate them that they can use the reasonable medical judgment. For the vast majority of Texas healthcare professionals who were not performing or referring for abortions before June 22nd, 2022, there should be no change to their practice. Thank you for stepping in, though, to protect mothers and their children and women of Texas.
Thank you. Austin Kaplan.
Thank you, Mr. Chairman, members of the board. My name is Austin Kaplan. I'm from Kaplan Law Firm. I'm a Texas lawyer. I represent plaintiffs in the Zarowski and Cox cases, along with co-counsel Molly Duane, Mark Heron, the team at Center for Reproductive Rights, fellow pro bono partners, the law firm at Orson and Forrester. But today I'm here just in my personal capacity, and like all lawyers, I will be brief. Our legal team will review and submit formal comments, but I fear that the proposed rule does little, does not enough, to change the dangerous situation for Texas women and their families. And so we might ask ourselves, under the proposed rules, can Texas doctors finally act when they believe the situation that presents is medically appropriate? Is Texas allowing the best possible health care to pregnant women? Is Texas keeping pace with health care in other states? New York, Maryland, you name it. I am sure that we are all here to work to make sure that Texas does not continue to force its own doctors to put pregnant women, to put Texas moms and their families in harm's way. And I'm looking forward to the rulemaking process and hopefully accomplishing that. Thank you.
Jonathan Covey.
Mr. Chairman and board members, my name is Jonathan Covey. I serve as the policy director for Texas Values. We're the largest organization in the state of Texas that works on the issues of faith, family, and freedom. We have over 100,000 supporters in all 254 counties. Just wanted to take the time to thank you for considering this issue. And as you know, and Mr. Chairman already mentioned, the Texas Supreme Court's recent decision in the Cox case shows that the regulatory delay is costing more time and more problems and exacerbating litigation efforts on this issue. We believe that every medical provider should know if a woman has a life-threatening condition, she must be treated. Texas law does not stand in the way of a woman receiving treatment. Texas law does not require physicians to turn away a woman with an ectopic pregnancy until rupture. Doctors do indeed have the discretion and responsibility to make such medical judgment calls, looking at the totality of the circumstances. Both of the major laws passed recently, SB 8, the Texas Heartbeat Act, and HB 1280, the Trigger Bill, both expressly provide exemptions from prosecution for life-threatening physical conditions arising from pregnancy. I would mention, and Ms. Sue already mentioned this, but Texas legal precedent has never found the term reasonable medical judgment to be an ambiguous term or to be a confusing term. I know you guys just published this in the Texas Register. We'll be taking a look at the proposed rules in the coming days as well and offering recommendations via a public comment period. I do think that I understand your reasons for not making the list. We'll see if the legislature provides additional clarity starting next January, and I highly anticipate that will be the case, especially since the actual language has manifested. But we appreciate the efforts to bring clarity for physicians and for pregnant women, so I just want to thank you for your time.
Thank you. Ingrid?
May I distribute something to the board?
Yes.
Good morning, board. Thank you for your service to the physicians of Texas and to their patients. I'm Dr. Ingrid Skopp, a board-certified obstetrician gynecologist from San Antonio, where I've been practicing for 30 years. In the wake of the Dobbs decision overturning Roe v. Wade and allowing Texas to implement the Human Life Protection Act, my practice has not changed. Although, like approximately 90% of obstetricians, I do not perform elective abortions, I have always been willing to intervene when a severe pregnancy complication has posed a risk to my patient's life. I understand this law, and I would continue to offer the same intervention to my patients today. Unfortunately, I cannot say the same for my peers. There is abundant documentation that physicians are confused and frightened. In many cases, they have not offered timely intervention. It has resulted in harm to women, including some unfortunate women in this room. These doctors are frightened. They feel that they are making decisions in a vacuum, and that if they make the wrong decision, they could lose their medical license, they could go to jail, and they could incur severe financial penalties. So I applaud you for taking this opportunity to provide guidance, much needed guidance in Texas today. I think what Dr. Zafran has read is a very, very good start, but there are a few other things that we need to be emphasizing. It's been discussed that reasonable medical judgment means what a reasonable practitioner, understanding the details of the case, the actions that they would perform. This is the standard of care. Doctors need to be reassured that they can continue to provide the standard of care in taking care of their patients. It is critical that it be emphasized to physicians that it does not need to be an immediate risk to a woman's life. We know what conditions can cause a risk to a woman's life, but we need to be reassured that we can intervene at the time the diagnosis is made. We do not need to be waiting until a woman is dying. And in fact, it was mentioned the Texas Supreme Court's discussion in the Cox case. They also affirmed immediacy is not required and a woman does not need to be dying. Doctors need to know that. Prior to the confusion, every hospital that I have worked at has had a therapeutic abortion protocol. I assume most hospitals still do. In addition, I would like for you to recommend to the hospitals they update their protocols and they make them known to the physicians so physicians know how to document when they decide to perform an intervention. That way they will feel that they are not making decisions alone, that they have the support of their medical organizations and the support of their hospitals. And I think that will result in much better quality care to the women of Texas. Thank you.
Thank you.
Before you leave, I just want to ask you, you're a physician, obviously, and I think
Yes,
you
sir.
brought up a very important point that I just want to highlight. I think physicians make good medical judgment, and I have heard anecdotal incidents where what a physician thought was the right choice to make may have been superseded by what a hospital was concerned about. And obviously we don't regulate hospitals, but there is a ban on the corporate practice of medicine in the state of Texas. And it's physicians who practice medicine, not hospitals. So I think not necessarily within this rule, but ideas, whether it's for an FAQ or something along those lines, to help reinforce that idea. I mean, we can do that because unless we know that there's a situation like that where a hospital, whether it's their legal department or whatever it might be, is superseding what a physician judgment is, it is important for this board to hear that. Because from our standpoint, that's practicing medicine without a license. So again, I just want to highlight that we've heard anecdotal examples of that happening. Maybe it was a little bit earlier on when the law was passed. Hopefully a little bit less now. But again, all these rules and the Supreme Court ruling talk about about physician judgment. It doesn't talk about other practitioners or entities, facilities, or what it might be as far as them making that judgment. So.
Yes, sir, what you've described is happening. I've seen it as well. And again, I just think doctors need to know that they're supported because they feel like they're alone making these decisions, and that's why we're seeing so much confusion and sometimes bad decision making.
Thank you.
Thank you.
Doctor, one more comment. I'm Dr. Kidney on this one.
Yes, sir.
And I wanted to thank you for taking the time and the courage and your candor in your presentation. I also wanted to comment on something that you said, and that was the idea of reasonable medical judgment. It's a rule that governs our lives as physicians every single day, every single decision we make, every single patient we see. It's not a new concept. It's not a novel concept, and it doesn't change for this particular purpose. I think that going forward, this board feels very strongly that physicians in Texas need to know that they have the support of the board as long as they follow the rules and use reasonable medical judgment and document. So thank you very much for bringing that point.
Yes, I agree, and I absolutely agree with your decision not to make a list. What we can do is we can look at ACOG's practice bulletins, and in many cases, they tell us the situations that are going to pose a risk. And if they don't, if there's not specific guidance, every hospital has a quality committee that can convene and can give doctors support in making these decisions.
Dr. Body?
Oh, I had here left over.
Oh, thank you. Appreciate it. Thank you for your time.
Thank you. One other thing to point out that you raised, Doctor, is additional language that's in Supreme Court opinion in the Cox case. And so and we did go and put, at least as of this point, some definitions that pull from other statutes. But that's why we also wanted to reference in the rule itself to be in compliance with court opinions, because those things can change. But those are things that, while each time something's cited in the court or even in other statutes, it may not be conducive to put it all into one single rule, as those things can change. Those are things that once we do get a final rule, we can put some FAQs and other stuff built around the rule and put some of that language in there. Because that way it's not the board that's coming up with it, but the board is putting it in a place where people can find it about, do I need to wait until there's an immediate emergency, and we can cite back to what the Supreme Court says.
Yes, I appreciate that. In our peer-reviewed journal, there was recently an article that said that immediacy was required, and he was quoting from a different section of Texas statute that didn't even apply to abortion. So that confusion, I think, is the biggest problem, the immediacy problem. So thank you for doing that.
Yeah, and as Mr. Carlton said, it's okay, you can, sorry. As Mr. Carlton said, I mean, rules are very, very prescriptive in how they're adopted. A very specific process in how we go about adopting a rule. There are clarifications and nuances that we can easily put into FAQs, and we've done that, again, going back to COVID. There were emergency rules that were put in place, and there were FAQs and guidances to put in place, because again, there can be nuances there that change very quickly, and if you try to come up with a new rule every single time you want to put those nuances in, it would be a 6-month process just to kind of get that through. So I want everybody to kind of understand that that concept is out there, that the rule is something that's very prescriptive, but there's opportunities for other clarifications to be made in other venues that comes as guidance from the medical board.
Rebecca Weaver.
Dr. Zafrin and members of the board, thank you for this time to give public comment. My name is Rebecca Weaver, and I serve as the Legislative Director for Texas Right to Life. Thank you for offering and approving these proposed rules to physicians regarding abortions and circumstances described under our current pro-life laws regarding medical emergencies. While our law is clear, implementation has proven problematic since Texas's pre-Roe laws retook effect after the Dobbs decision in June of 2022. This confusion is unnecessary, and we are pleased you have chosen to help clear the confusion. Texas's pro-life laws clearly permit physicians to intervene when a pregnant woman's life or major bodily function is in jeopardy because of her pregnancy. We appreciate your action to clarify this for physicians. Based on your reading of the proposed rule, we're glad to see that the rule restates definitions already in statute, adhering to our current laws, and not weakening the strength of our laws. We also appreciate that you've chosen in the proposed rule not to list out circumstances, but defer to reasonable medical judgment. We do want to make sure these rules emphasize that imminence is not necessary, that women do not need to be at death's door before physicians act, and we'll submit this in writing when the rule is officially published. None of us want pregnant women put unnecessarily at risk when the law is clear about taking action. Thank you for your service to our state, for your time and consideration, and for approving release of these proposed rules.
Thank you. Senator Eckhart?
I'm not speaking,
No, okay. All right.
but thank you.
Yes. Taylor Edwards.
How big I am? How big?
Thank you so much for your time today. I am a plaintiff in the Zurowski case, and I kind of have yet to hear something in these rules that would address my situation. I was given a fatal diagnosis at my anatomy scan. Sorry, I just had myself here. I was given a fatal diagnosis at my anatomy scan. A diagnosis that 2 maternal fetal medicine doctors and my OBGYN confirmed that their medical judgment was an abortion. That was the standard of care. They were unable to give me an abortion because they risk life in prison and losing their medical license. No one should have to risk that to give medical care. It shouldn't be something that's even an option. And I also am concerned about what our state government is doing to protect and help mothers and families, and what's being done to address the public health crisis created by the state's abortion ban. I had to flee the state, and to leave the state, I had to navigate a lot of obstacles, including rescheduling appointments several states away. That shouldn't be what's happening to women in Texas. I am currently pregnant today because I've got an abortion. I will get to be a mother because I got an abortion. That is something that I think is being missed with all these conversations about lists and unborn babies and all of the things. It's just being overlooked. That this is real, this is happening, and this is not a one-off situation. And the last 2 years, our doctors having no guidance on what to do has caused so much suffering, and I really hope this suffering doesn't have to continue.
First of all, I want to commend you for coming out here and speaking, because I think that's very brave, and it's by no means easy to come here and speak about that. Rest assured that we are trying to, within the framework of the law, come up with a mechanism to where those physicians that you said decided that that was what was medically necessary would be able to do so. And that's our intent. So we're hoping, and again, this is preliminary, and I understand that things take time, and that's unfortunate. I wish we could have done this. I wish we could do this right from the get-go. But we are where we are right now. But again, like you stated, you had at least 2 physicians state that this is what was medically necessary. And what we're hoping is that by giving clarification that we are yielding to medical judgment, to reasonable medical judgment, that you should hopefully not get into a scenario like that ever again. So thank you for coming out here.
Thank you for your time.
Travis,
Hey, thanks for taking the time to talk to us today. I'm Travis Edwards, the husband of Taylor Edwards, who we just heard from. I want to start by saying that there are a few things that I actually agree with you guys on, and that is that you should not be making a list of exceptions, because it's impossible to foresee every possible circumstance and the extenuating circumstances around all of those exceptions. So I agree with that, and I agree that reasonable medical care should be in the hands of the doctors. I think where it starts to fall apart for me a little bit is that the legislative branch of our government has so much control over this situation. As you said, you can only go so far within the bounds of the law as it currently stands. And much of our legislature is not medical doctors, have never practiced medicine. Most of them, have not even spent the time to talk one-on-one with doctors about the situations that they've seen. And so, to me, I think that's where we need to kind of take another look at it and say maybe the legislature has gone too far and has overstepped their bounds, and we need to put more power back into the hands of the medical board and of the physicians who are making these decisions. As Taylor stated, there really hasn't been a direct, a direct addressing of the situation that we faced. Much like Kate Cox, we were told to leave the state in order to get the care that we needed. We still see a lot of those same doctors for our current pregnancy that we were seeing before. So we don't feel like it was the fault of the medical staff. We don't feel like the doctors were doing anything malicious towards us or had anything but our best interest in their hearts. So we still trust those doctors, we still see those doctors, and we hope that more doctors can have their medical and professional opinions be the driving force in the decisions that they make with their patients. The decision should be between the family and the doctor, and they should be able to make the best decision for them. A lot of the so-called anecdotal situations that these women have been in, and the immediacy argument, I think, to me, it's not anecdotal. I've spoken to those women, I've spoken to their husbands, I've seen fear that they were put in when they were told that their wife was gonna have to have her life on the line before the doctor could do something. And to me, I don't know how any medical doctor in this room can sit here and say that that's the way that they would want to practice, that they would be forced to delay care until the situation becomes an emergency. That just, I can't imagine many doctors would be okay with that. So I thank you for trying to clarify that and for doing your best. And I hope that we can continue to make progress on this issue. Thank you.
Is it Kosh? Cash.
Thank you for having me today. I'm also a plaintiff in the Zawoski case, and I'm here because this is very personal to me and to my family, but again, I get to hear something in these rules that sounds like it will address what happened to me and my family. My child was diagnosed with a host of genetic conditions, one of which was osteogenesis imperfecta, or brittle bones, meaning that if I bent down to pick up my toddler son while I was pregnant with my second child, I would run the risk of breaking his bones. The mental anguish of carrying that pregnancy to term would have killed me. It would not do any bodily harm, as you've listed in your rules, but I probably would have taken my own life to end my child's pain. So I do hope that you will consider the recommendations of a mental health professional in your two-provider rule for reasonable medical judgment. I've heard you say that you don't make the law, but I'm here today because I've tried to get the legislature to act when I lobbied last session and couldn't even get an amendment for fetal anomaly out of committee. I tried to get the courts to help explain what would happen in my situation as a plaintiff in the Zawoski case, and they said that we needed to wait for you. And now you're saying it's not your responsibility either. So where else am I supposed to go? Again, I want to be very clear. Your ruling did nothing to address fetal anomalies that hundreds of women face. I would have given my life to take away my child's pain like any mother would. Your decision to leave fetal health out of your rule will only leave confusion for providers who are counseling parents who are doing the best they can. This is what abortion bans do. They strip away dignity and autonomy from pregnant people, and they take away our rights to decide what is best for ourselves and our families. In my case, having an abortion was a compassionate parenting decision, but regardless of anyone's need for an abortion, these bans set up pregnant people to feel like criminals, forcing us to beg for empathy from the courts that have now normalized suffering and dehumanization of women and mothers. I am here today because I had an abortion. There was nothing that could have been done to save my child's life, but an abortion saved my life. And it made it so that I could be here today to stand up for the other hundreds of women who face situations like mine. So thank you for hearing my statement.
And again, like I said earlier, thank you for coming and, in a public setting, being able to tell your story like that. I know it was not easy, so thank you.
Amanda Zarowski.
Hi, thank you for taking the time today and for allowing time for public comment. I was wondering if I could also have Mayor come up with me.
Yes.
He's next on the list. My name is Amanda Zarowski. This is my husband, Josh Zarowski. I am the first named plaintiff in the aforementioned Zarowski versus Texas case, a case in which the Texas Medical Board is a defendant. I am very hopeful that the actions you're taking and the clarity you're seeking to provide will help physicians understand when they can provide abortions, but I am skeptical. I'm curious to understand more why you're agreeing to address this now, when for years we've been asking for clarification from the legislature, from the courts, and/or from you. So I am curious to understand what got us to this point specifically. I'm not a legal expert, I'm not a physician, but it does feel to me like a lot of finger pointing is going on. On the one hand, we have the Supreme Court telling us that this decision is up to you, and the clarity should be something that you provide. However, today it sounds like you're saying the opposite, and that it's not within your jurisdiction, and that the Supreme Court should actually be the ones to make these decisions. So it's very confusing. And I would still like my attorneys to be able to review the full text of the rules, which so far they have not been able to do, because I'm concerned that the rules only repeat the language that already exists from other statutes and rulings. But in addition to repeating the existing language, it sounds like it's now potentially going to add further burdens for physicians in acting through these documentation requirements. And to me, that sounds like it would just further delay physicians from providing the health care if and when they deem it necessary, sometimes to save a life or to prevent someone from almost dying, which is what happened in my case. Had my physician had to wait any longer, I probably would have died. So I am hopeful. I hope that you will help physicians in this state so that people like me don't have to continue suffering, and so that our future families are not forever impacted. Thank you.
Yeah, I'd like to, thanks for the rule that you guys put out today. I think there's been a word that's been talked about, the word reasonable medical care, that phrase, and that seems to really be the crux of the problem here. And one thing you'll note, that the folks in the, that want to legislate abortion are very happy that you're falling back on the reasonable medical decision language. And the reason why is because they know there's a person who is not reasonable, who will, and has already shown in the Kate Cox case, will challenge doctors who are making reasonable medical decisions. So if we hold that as the standard, expect that doctors will want to use, and if they do, as soon as they do, they will face enforcement from the state, and as you laid out earlier, will then have to go through a process that could include suspension, a very cumbersome process for these doctors, and you're putting them now in a position where we're right back where we started. They will not want to take action because they're afraid. So the circular logic that's happening here is exactly what put us here in the first place and is going to keep us here. I understand this is a big challenge for you guys, so I'm not saying there's an answer, but there's a very clear problem that I think we just need to be honest with ourselves. This is where we're at. And I'd like to also point out that it is not reasonable for families like what we went through to, and as a hopeful father, to have to take my wife to the hospital myself against any rational, no person should have to ask themselves, can I take my dying wife to the hospital? And we're gonna stay in that particular situation if we continue to fall on this reasonable medical decision. Thank you.
Amy O'Donnell?
Does it matter which one is
No. Before you start, one thing that I would just make a comment on, we did look at statute language as we adopted this proposed rule. There may be other language that we may have been able to use or could use. Our stakeholders and our commenters pointed it to us. And of course, if it's coming from statute and it helps clarify things even more, we would be very open to that if it is coming out of statute. And I could already see some possibilities out there. So I would encourage those who are putting public comment out there, if you were to look at existing statute and language coming from there that would actually help to add clarity to that and make those suggestions to us, that would be extremely helpful. Okay, sorry, go ahead.
Hi, my name is Amy O'Donnell. I'm the Communications Director for Texas Alliance for Life. And I'm here today to advocate for the board to set forth rules explaining to physicians the meaning of the medical necessity section of the Human Life Protection Act, the law to protect unborn babies from abortion that the legislature passed in 2021 during the 87th regular session. We are grateful the board has taken this up for consideration today. It's important to note as you consider this important issue that Texas abortion laws are saving unborn babies and pregnant women's lives. Induced abortions performed in Texas are required to be reported to the Texas Health and Human Services Commission, and the numbers are recorded on a monthly basis in the Induced Termination of Pregnancy Reports, also known as ITOP. The latest information from the reports, which we have summarized on the attached sheet, page 2 of what I handed you, shows 2 relevant trends. First, the law saving unborn babies' lives. Reported elective abortions plummeted from thousands per month to 0 after Dobbs reversed Roe. Second, the law is saving pregnant women's lives. During the first 16 months after Dobbs, from July of 2022 through October of 2023, the latest month of available data, doctors performed 71 abortions, all in hospitals that fell under the medical necessity exception of the law, according to section 178.002 of the Texas Health and Safety Code, to save pregnant women's lives or prevent risk of loss of a major bodily function. We believe that fertility is a major bodily function. No doctor has been prosecuted by a district attorney, sanctioned by this board, or sued by the Attorney General. No pregnant woman has lost her life for lack of an exception, even with more than 360,000 births in Texas each year. This shows that the exception in the law allows doctors to perform abortions to save pregnant women's lives in those rare and tragic cases when medically necessary. We hope that the rules that you propose will explain that to any physicians who do not already understand Texas law. Thank you.
I think we had a few seconds left, and I just wanted to comment on that, if that's okay.
Well, let's let the others go, and then we'll. Jennifer Allison.
My name is Jennifer Allman, and I'm the Executive Director of the Texas Catholic Conference of Bishops. We would like to thank the board for putting forth the guidance that you've put forth today. We look forward to reviewing it in greater detail. I think perhaps the most important thing you've done is you've provided physicians with a roadmap to understanding the statutes. I think the difficulty and confusion in part is caused by the fact that these definitions are in different chapters and different statutes. And so your rules give a one-stop shop for physicians to know and understand the issue. I also wanted to reiterate that Catholic hospitals throughout the world have been providing emergency medical care and emergency pregnancy complication care without ever providing an abortion for over 100 years. So it certainly can be done, and I think that's important to know as you move forward. I think the definitions, sticking to the statute is really important. So I really appreciate that. Women seeking treatment for high-risk pregnancies or who've lost the pregnancy that they have in the process of losing their unborn children should not have to go through the anguish that we have heard about because their physicians are confused. And so putting forth this information, we hope, is an important part of the solution. I appreciate that the board has been responsive to the suggestions people have made and looking for ways to further improve upon the start that you've had. I would echo what Dr. Scott talked about in terms of the immediacy or urgency issue. I think that remains a really important issue to more clearly address, and I think it's possible to address it with existing statutes and, as you say, looking around to other portions of the statute. So I thank you for your time and appreciate the fact that you are taking this very important issue so seriously and trying to make sure that you are encouraging doctors and informing doctors on how to provide the best care possible for women and their children. Thank you.
Last name, Wright.
Good morning, members of the board. My name is Kylie Wright, and I'm the president of Texans for Life, one of the stakeholders who advocated for the Human Life Protection Act, also known as the Trigger Ban. And while we haven't yet seen your guidance, I was able to listen to your description of it and really appreciate what appears to be a very strong effort to stay true to the statute. So thank you for that. We are grateful for your work to clarify what now seems to be so confusing for doctors. And I say now because these same medical exceptions in the Human Life Protection Act have been in law and in effect for over a decade in Texas, having been included in the state's 20-week ban, which passed in 2013, with no complaints, no sanctions, investigations, or confusion. Even in the months since the law went into effect, dozens of abortions have been performed to protect the mother's life. Clearly, all doctors are not confused. And while the media waxes on about doctors being scared and confused, a closer look reveals a somewhat different story. Take the case of Kate Cox. Mrs. Cox, a Dallas resident, sought help from a longtime abortion care doctor in Houston and ultimately then filed suit in Austin with the Center for Reproductive Rights representing her. Original claims that this pregnancy threatened her life fizzled when she failed to even make that claim in depositions or her appeal to the state Supreme Court. After learning that the primary reason Mrs. Cox sought an abortion was a life-limiting diagnosis for her baby, we also learned that from Texas Monthly's interview of her doctor that the doctor was not at all confused, but rather frustrated that there weren't exceptions in the law for babies with tragic medical diagnoses, for rape and incest and even depression. In other words, the Planned Parenthood doctor who performed abortions for 14 years wants to continue practicing under Roe v. Wade, which is no longer an option in this state. In the Fort Worth Star-Telegram and other print media covering the longer story, we hear the same thing from different doctors. These doctors are unhappy and frustrated that there aren't more exceptions in the law. Well, there is a process in place for changing laws that we don't like, and it is not in court or at the Texas Medical Board. This effort, coordinated by the Center for Reproductive Rights and Planned Parenthood, is nothing more than a backdoor attempt to do what this board is not legally permitted to do, and that is expand the exceptions to the greatest extent possible at the expense of preborn babies. And I trust and do appreciate that you appear to have clearly seen through this and are making a great effort to stay true to the law, so thank you.
Looks like it's just a person, Amy. Okay. Last name, V-O-N-A? Sure. No? Okay. Dr. Ivy.
Hi, good morning, and thank you for the opportunity to speak. I'm Dr. Richard Todd Ivy. I have practiced obstetrics and gynecology in Houston for over 30 years. I'm speaking here today on behalf of the American College of Obstetricians and Gynecologists, District 11, and the 3,268 practicing obstetrician gynecologists in its Texas section. Collectively, we welcome the opportunity to work on this important issue. As many of you have seen in the news, The language in the current statute has created confusion for our physicians, our hospitals, and our patients. This confusion has led to delays in the provision of appropriate care with increased morbidity, unnecessary suffering, and alterations in people's plans for family. I certainly understand the concept of reasonable medical judgment, but in this area that's so heavily scrutinized and the penalties are so severe that I think it's appropriate to understand a physician's confusion and hesitation in this arena. As physicians, we believe our patients need unimpeded access to the full spectrum of reproductive health care options. It is absolutely unacceptable for doctors and healthcare professionals to be punished, fined, sued, and face imprisonment for delivering evidence-based care. We recognize that abortion, for any reason, is a complicated topic. We also recognize that the decision to have an abortion is a very complex one. In all my years of practice, I've never seen someone reach that decision easily. It is for these very reasons that this decision should be left to the patient and their trusted healthcare professional. Doctors and clinicians must be able to provide unbiased, factual information to patients regarding reproductive health care options. And people must be able to use their own judgment in making their healthcare decisions for themselves and their families. With your leadership, we trust that the physician-patient relationship will continue to be respected. We are grateful for the opportunity to review this rule today and will offer thoughtful scientific commentary during the next 30 days. Thank you.
Thank you. Kathy Toro. Kathy Toro. Marked again, initials CC. That we did respond before we move on to the virtual attendees. Is there anyone else?
Where are you going? Let's just do it here.
We're not allowed to.
Oh.
Did you just say that?
Stay here?
Yes.
Well, I can stay here as long as you're
Oh, okay.
Joey said they're not allowed to. Oh, even if they're with me? Let me call them now.
It's fine. We'll go downstairs. We don't have time to go back to work. Okay.
Yeah, the question is answered by the board members, not by us. We would have to ask.
Okay. Thanks for trying though. Yeah, I tried. Yeah. Sorry about that. I'm just a building manager.
Like I told him we weren't gonna be 11, then he just put me in 11:30. I'm like, okay, could you have told me that? I have like no script, so I just.
I saw something that said that we were moved to 11:30.
Well, that's great. I doesn't tell me that. And I was just trying to get the rules. I hate this.
You know, people are on Fridays. It's not the best day of the week to do stuff like this. Can't bring me down on a Friday. And the sun came out. Yeah. So I think it's gonna be a great. It's gonna be a great day. Yeah. I'm driving straight from work to camping. Oh, that's nice. It's gonna be a good weekend for that. Yeah. You guys go.
on the phone and tell me you're not ready.
I just have one day to do a story. Okay, well, my computer's broken. I can't, my computer's not working. It's just frozen. I don't know why. Like I told him I'm not going to be in midday, and then he just uses that as an excuse to go, you're going to be missed. And I can't look at messages because I'm trying to focus and listen to what's going on and figure out what's actually
I
happening.
just told him we're not going to make 11:30.